Good afternoon, Chair and honorable members. Let me use this time just to check with interpretation. French, are you good? Thank you very much. Portuguese?
Problema de interpretação. Okay.
Portuguese? Thank you. And Portuguese, French?
Tá. Perfeitamente.
Yes, Chair. I'm just checking with Professor Maduk and Justice Dingake to make sure that they are in the meeting. I'll come back to the Chair just now.
Correto.
Esse aqui como chama isso da empresa, no Jornal do País, fizeram assim. Chegaram aí, é decapitado.
Quem foi? Quem foi?
Our presenters are in the meeting and the members are in. Over to the chair.
Muito boa tarde, caros colegas. Vamos retomar a nossa sessão nesta parte de tarde, convidando os nossos oradores para darem seguimento com nossos trabalhos desta tarde. Muito obrigado. Convido agora o doutor Lovimon. Epa, esse nome.
Good afternoon, Madam Chair and the honorable members and Justice Dingake. We are proceeding now this afternoon to look at. I can proceed. Okay, thank you. I can proceed. We are continuing, honorable members, on the topic that we started in the morning, which is the role of Parliament in protecting constitutionalism and the rule of law. I just want to remind you that when we started, I made it clear that in terms of our topic, Parliament has a role to play in protecting constitutionalism and the rule of law. I must emphasize that again. Parliament has a role to play. This does not mean that Parliament is the only institution that protects constitutionalism and the rule of law. There are other institutions. Justice Dingake made it clear in his intervention, for example, when he gave examples of the importance of an independent judiciary, when he gave examples of the need to protect human rights, when he also, and I'm sure he in his intervention might add more, he made reference to the issue of corruption. So what we are doing this afternoon is to take the theme further from the roles that we specified in the morning. There are so many issues that do arise, which would ensure that Parliament may actually face challenges. Remember that our topic refers to what are called prospects and challenges. So the challenges would be the kind of difficulties that would come around in the event that we are trying our best to enforce these things. So I will now be looking this afternoon at the relationship between Parliament and other players in the process of ensuring that we have protection of constitutionalism and protection of the rule of law. So I want to start with the relationship between Parliament and the judiciary in the process of protecting constitutionalism and the rule of law. First and foremost, the judiciary is an independent entity. And so the judiciary is given the task of resolving disputes by applying the law. It is given the task of ensuring that it is upholding the rule of law. But before the judiciary comes in, members of the judiciary are appointed to those positions. And it is important for Parliament to ensure that persons who are appointed to the judiciary are persons with the requisite integrity to be able to maintain an independent judiciary and to be able to maintain the rule of law and constitutionalism. So I would say that in each of our constitutions, there is some role given to Parliament in relation to the appointment processes of judges, and sometimes in relation to the retirement of judges. One example is that you cannot, in some countries, fire a judge without the approval, ultimately, of Parliament. That's the ultimate control. We have that in South Africa, we have that in Malawi, we have constitutions that ensure that ultimately there is. So I would say that this afternoon, we must take note of the fact that when Parliament is sitting and wanting to ensure that there is constitutionalism and the rule of law, it must itself as Parliament respect an independent judiciary and take steps to ensure that the judiciary remains independent. And what steps may Parliament take? First, Parliament must take the steps that may be provided in the Constitution. If the parliamentary process is actually provided for them to be involved in interviews. I'll pick one situation where the appointment of the Chief Justice requires the approval of Parliament. There is a constitutional framework like that. Parliament must not then rubber stamp a proposal coming from the executive on saying this is the person we propose to be Chief Justice. If Parliament does not realize the importance of the judiciary, then Parliament will not be able to play that protection. Its protection there comes by way of saying, well, give us more detail. Is this person suitable? And so forth and so forth. So I would say that the relationship between Parliament and the judiciary is quite key, to the extent that Parliament must play a supportive role in ensuring independence of the judiciary. But the most important supportive role that Parliament must play to maintain an independent judiciary is where Parliament ensures that the judiciary has sufficient resources to be independent. The executive is very good at controlling the judiciary via controlling resources. So they make sure that judges do not have sufficient resources to operate. They make sure that judges have no transport, have no vehicles. They also make sure that there remains a relationship between judges and the judiciary, and the judges and the executive to be able to get, things that are common cause. The salaries that are payable to judges, how are those determined, and so on. Madam Chair, it is very important for Parliament to realize that for it to protect constitutionalism and the rule of law, it must protect the independence of the judiciary. And for Parliament to protect the independence of the judiciary, Parliament must make resources available to the judiciary. So when a budget comes, in parliamentary vote and so on, various votes, a Parliament that is very conscious of the rule of law and constitutionalism will go to the line item that will go straight to the judiciary and say, is this sufficient for them to be able to? And there's nothing wrong from time to time for the parliamentary committees to be able to interact with the judiciary insofar as resources are concerned. So that is the point that I wish to make in relation to the relationship between Parliament and the judiciary. Remember that there are two institutions, but these institutions must be interrelated. I am not done yet on the relationship between Parliament and the judiciary. I go to the controversial area that I am sure that Justice Dingage might also want to comment on it. It is where the judiciary gives out judgments that are seen by the executive to be not good judgments, or where the executive is very fond of attacking judges for being political. Say that judges are being, partisan. This judgment of the court is politics. The courts are playing politics. And most people who make lots of noise around the judiciary making certain judgments, they would be members of the executive, the president and his or her ministers. Now, what is the role of Parliament in such a situation where the executive is unhappy with the judgments of the courts, which the executive will just simply describe as being unpatriotic, or judgments that are against the executive for political reasons. What should Parliament do? My experience in SADC in Southern Africa is that the MPs simply join the executive in condemning judges. The MPs become also politicians, say, judges are not behaving well, judges have crossed the line, judges have done, things like that. We have so much of that taking place. I would like to present here and submit to this committee that Parliament in that case must actually come in and play a checks and balances role. Parliament must be able to call off the executive when the executive goes beyond boundaries and says, look, you are the executive, leave judges alone. It will be a better protection of constitutionalism and the rule of law if Parliament is able to stand and defend an independent judiciary. Obviously, there might be areas where the judiciary might overshoot or go beyond bounds and so forth. If that happens, there can be fair criticism. But for Parliament, the role of Parliament is to say to the executive, if you are not happy with the laws coming out of the courts, bring proposals for amendment or for reform with us. And that can actually play a critical role. I'm saying this because in other countries outside Southern Africa, we have had good experiences of Parliament being the place where everything is cooled off when there's this heated debate between the executive and the judiciary. When Parliament does that, as I'm saying, it will be protecting the rule of law and protecting constitutionalism. That is clear. So that's my first area which I thought we should look at, the relationship between Parliament and the judiciary. As I've indicated, that relationship always must remain a very viable relationship where one depends on the other. Especially the judiciary will depend on Parliament if it is receiving unfavorable comments from the executive. At the same time, Parliament can actually be sensible. If there are situations where the public is perceiving certain judgments or perceiving the behavior of the judiciary to be out of line, there's nothing wrong with some parliamentary debate properly controlled that raises that point in the parliamentary chamber, because after all, Parliament is the representative of the people. Then I want to move on to the second issue that I want to cover in terms of enhancing the role of Parliament in the areas that it is how Parliament ensures public participation. We saw in the morning that one of the roles of Parliament is to ensure that there is public participation. But now this afternoon, I'm now deepening that aspect and saying that how best do you ensure that the public is involved? When is the public involved in parliamentary processes? This is a very important area. It is important because of what the courts have said. The courts have said that Parliament must engage the public, but as to how Parliament engages the public, we leave it to Parliament to determine the mechanisms it will use to get public inputs. This is clear that so Parliament is left with a huge room to do that. Now, some parliaments use profitably the system of portfolio committees or parliamentary committees that go out to carry out, public exercises of finding out from the people what they think. And then some, apart from that, these parliaments also allow the public to send in petitions or written submissions on what is to be debated in Parliament. Now, the issue I want to raise with you, and which I'm saying is important for the protection of constitutionalism and rule of law. When Parliament allows the public to participate, it is entrenching democratic rule by getting the inputs of the people. And as we have said in the morning, democratic rule is part and parcel of the rule of law. Democratic rule is a very good example of good constitutionalism. So it's how you treat these submissions which matters. Now, if you get inputs from people and you all completely ignore everything that came from the people. You go out there, people say out what they think, they voice their concerns and say, look, this law is not good, the proposal is not good, and so forth. Then when MPs get back to Parliament, they merely report what people said. Then they get back to what we heard from some of you during in the morning session, that they now listen to their political parties. They go out to the public. When you meet the public, people who meet MPs or members of Parliament, they don't meet them on the basis of party positions. These are members of the public who do not belong to any political party, and many of them may not have voted in the previous election, or that, and so on. And some of them will never vote. But when the Constitution says public participation, it is not looking at the participation by voters or participation by the electorate, which is what some members of Parliament, some politicians would want to portray. When we say the public, we don't mean the electorate. The electorate is a small component of the public. By public, we mean every person, other than that, those who vote. I'm sure all members of Parliament here will know that in most elections, you'll be lucky to get 60% voter turnout, but that is 60% of the adult population. So we must separate the adult population, that's those who are 18 and above. Then there is the population which is not adult, the minors, those who are below 18. They are there, out there. Then there are many in the adult population who are not active voters. So when MPs go out to consult people, they must not focus exclusively on the electorate or those that participate. From my experience, and I want to say it openly here, most members of Parliament prefer to interact with that component of the public that is the electorate, because they do it with a view to re-election. They do it with a view to ensuring that they are seen to be working. So when you get public inputs, you must take these inputs seriously. They must be reflected in the amendments that then take place within Parliament. They must be reflected in the debates. But my experience in Southern Africa is that consulting people is merely a dressing exercise. It is just to dress up matters and say, we consult the people, but you are not in any way taking into account what they are saying. I have examples that I would not want to give now already of some countries, but it is sufficient for me to say this. Get inputs there, take the inputs seriously, use so many ways of getting the inputs, not just meetings and so on. I am at liberty to give the example of my country here, Zimbabwe. When it comes to portfolio committees, they would publish meetings, but you will see that they follow the main center. So one portfolio committee, which is supposed to be consulting, only has about 12 meetings around the country, or say, let's put it at maximum 20 meetings. But they never reach 20 meetings. I think that it will be about 12, 15 meetings. We go by their adverts. These meetings are held at centers. So you go to the main centers, you are in Harare. In Harare, you have one meeting. You go to another center in Bulawayo and so forth. Then the people that come are normally the urban active persons, or a few active persons that come to attend the meeting. That cannot be called a complete consultation or a public participation that the Constitution has in mind. What it has in mind is that apart from those meetings, I know that some people are asked to write, but they have not been doing a lot. Have radio programs where people phone in. The parliamentarians are on radio, and then they are having their program, or they are on television, and they are in phone-ins. The Parliament must expand the scope of its getting inputs. But my further worry, when I give the example I've given now, is that when some inputs come like those which are written, they are not read by MPs. MPs then just ask their officers of Parliament, some clerks there and so forth, to analyze the data, give us a summary and so forth. That is fine and good. But I think that an MP who is very conscious of their work must go beyond relying on summaries that have been prepared by parliamentary officers. You must also sometimes go to the raw data, take all those files, read through them to get what people are saying. You will be surprised how much you miss out as Parliament, on the issues that come in. Then that is an area where I believe that Parliament must deepen its participation. The South African Constitutional Court has given a judgment where it says that if Parliament fails to do that sufficiently, the law that is passed may actually be set aside or declared not valid because there was not enough parliamentary participation by the public. But of course, the test for them to set it aside is very high. They will have to say, no, this is, and they have had a few cases where they have succeeded in doing that. Outside there, we have not yet come across another country in Southern Africa that has gone that far of actually setting aside a law passed by Parliament on the basis that that law was not done with sufficient public input. And this is a point that we need to, but the lesson that I believe we can take from what we are discussing at the moment is that ensure that there is public participation. I go to the third item of this afternoon. The third item of this afternoon relates to parliamentary procedures and the role of Parliament in that process of parliamentary procedures. You will all know that Parliament operates through its standing orders or rules of procedure that regulate Parliament. Have you ever imagined how important those rules are and how much power Parliament has in that regard? Parliamentary procedures, as far as I know, in the whole of Southern Africa, are the kind of procedures where the executive does not get involved. Remember, when you pass other laws, you will need the presidential signature or the signature. The laws, proposed bills passed by Parliament have to be signed into law by the president or the head of state. And so, which means that there is someone who comes in and says, look, we are not signing this, or I mean, each of our constitutions will try and provide a framework where that would happen. But when it comes to parliamentary procedures, standing orders of Parliament, these start and end with Parliament. It is the parliamentarians that discuss the standing orders. And after you are agreed, you pass them yourself. They don't go to the president for approval. And once they are passed, they become law. That's a very critical position. So you must, my point I want to make now is we look at the rule of law and constitutionalism. Parliament has a role to make sure that its parliamentary procedures are democratic. They are open so that they can easily be used to promote this. And they have to be. You see, the kind of rules where you try and protect behavior of the MPs, do it within limits so that on the one hand, you allow them to be as free as possible. At the same time, they must also maintain the dignity of the House. Those you must strike an appropriate balance. But the point I'm making is that make your rules of procedure such that they promote constitutionalism and the rule of law. I would give an example. What the rules, many of the rules that I have studied, they are very weak when it comes to dealing with ministers who are in a way politely disrespecting Parliament. Take ministers who do not come. They do not attend sessions when they are asked to come and attend and to answer questions. Ministers who keep on postponing their answers to questions, and sometimes, and so on. The rules are not very hard on those. There must be clear provisions as to how you govern that process, etc. Then you also have other parliaments that still do not have rules for question and answers by the head of government, who is the president. I think that there must be sufficient scope within your rules for Parliament to invite the president to come and answer questions, not the president just to come and address Parliament. You ought to, whenever the president is also head of government, apart from being head of state, that component of being head of government is not adequately reflected in Southern Africa. That's the point I'm making, Madam Chair. In Southern Africa, the role of the president as head of government is not adequately reflected. We have one example, I think you have seen that, I think the South Africans do allow the president to come and answer questions from time to time. I have also seen outside Southern Africa in the Kenyan processes and so forth. I think we need more of parliamentary procedures that facilitate the coming into parliament of the head of government, who is the president, and for him to answer questions. Of course, the president comes to parliament as head of state, perhaps to do the ceremonial functions of opening. Those two functions of a president must be kept apart. The president as head of government and the president as head of state. Where the president is head of government, he must or she must somewhat interface with parliament. So I want to challenge you, honorable members, that if you are coming from a country, and that's coming to almost all our countries, where the president is both head of state and head of government, there must be room within parliamentary procedures for the president as head of government to be able to be subjected to processes that would ensure that we work around that element well. So that is my third point. I hope you've understood it is about parliament must attend to its parliamentary procedures. It must deepen those parliamentary procedures, make the parliamentary procedures conducive to democracy or democratic entrenchment. Do that. And although I've given the example of ministers, I also want to give examples of your interface with the public. Some of the procedures are not very conducive to public participation and public roles when parliament is in session. Of course, there is a system where the public can be sitting in the public gallery. Access to the public gallery must be fine. And then there are many countries that still have not reached the stage of televising parliamentary sessions or televising parliamentary debates. So we have a few countries. I don't want to keep mentioning those countries. But if you look at Southern Africa, we must all aspire to ensure that parliamentary processes are open to the public in terms of either via the media, television or radio, and also that those who can physically attend parliamentary business can do that. That's under my topic on enhancing parliamentary procedures and making sure that that clearly is so. Then the fourth area where I want to again say in enhancing thing is the area of the censoring or somewhat dealing with the head of government as a measure of trying to, on behalf of the people, to say that the president is wrong or the president is not acting properly. And here I'm looking at parliament and votes of no confidence and impeachment. So those ones, I am putting them under one heading, votes of no confidence and impeachment. Here, as we saw in the morning, the role of parliament when it is given, this is a role that parliament gets to be given by the people in a constitution, to say that it shall be parliament that will pass a vote of no confidence, or that it is parliament that will undertake an impeachment process. Allow me to say this: when the constitution makers or anyone who is making a constitution says, so how do we go about it? They always have parliament in mind, because parliament is held by the public in high esteem. It is the highest organ with people's representation. It is the most important institution that you can have around. And so you say, look, we can't all sit around and say the president is not doing well. He must leave office. Say you are thinking of a vote of no confidence, or that the president must be removed. You are thinking of an impeachment, and you do it. Now, I think honorable members around would know what the parliamentary process in the United States was doing in relation to President Trump. And we had so many lessons to draw and so many criticisms to give. That parliament wanted to impeach President Trump when he already left office. I think that's what happened. You saw that. Then the parliamentary process there in terms of impeachment was politically partisan. Those who voted to impeach the president in the House of Representatives did it exclusively mainly on a party line. When it went to the Senate, it was again a party line. at the end of the day, the whole impeachment process became hugely political. It is political, yes. But from it, we must say there is room for Parliament to ensure that these things are taken seriously. The South Africans have been doing lots of these votes of no confidence. And I know that each time they've been trying to do it, they always boggle down with the rules. They don't know what rules to apply. Sometimes they make new rules as they are going and so forth. Parliament must not be found wanting. It must have a very clear procedure, which is a separate standalone procedure, even in the standing orders, but which deals with this very important task of how do we handle a vote of no confidence and how do we handle an impeachment process and so forth. We had, apart from the confusion that we sometimes see in South Africa, we actually had a huge confusion in Zimbabwe when a suggestion was made that the president, former President Robert Mugabe, be impeached. And in fact, impeachment motions were passed and carried through Parliament to then start the process. Our Parliament was very confused. A number of the MPs actually thought that the president had no right to be heard. Say, no, why do we hear him? We are going to be meeting. They actually chose a venue where they were going to be voting within hours and so forth. Those things happen, but they were caught unaware. Yet the Constitution does provide for these things, and it will be important that those things are taken seriously and they are actually implemented ahead of them causing problems and so forth. Then the fifth thing that I want to refer to is sensitizing members of Parliament, or I'll call that capacity building of MPs. Right, that's my fifth point. For Parliament to be able to protect constitutionalism and to protect the rule of law, the members of Parliament themselves must be capable. They must know the importance of these things. They must know their role. They must actually have a deepened understanding of what they're supposed to be doing. Our parliamentary process is open, except for a few countries, I see in Zambia and so on, where you have a provision that says you must have a particular level of education for you to be elected as a member of Parliament. The majority of the countries don't do that. They go by the demo. Whoever is elected is a member of Parliament. But being elected does not automatically give you the knowledge and capacity to do your work. I mean, that's obvious enough. So once you are elected and so forth, it doesn't follow that you will be able to do your work properly. You ought to get, so the Parliament itself must devise a very effective capacity building program so that you get in the first year of MPs being elected, because we must work with what we have. Those are the people elected. The first few months of a parliamentary first session in Parliament is to train the MPs. Deal with what you see. I think this is one of the weakest aspects in Southern Africa. You get the MPs, the Secretariat of Parliament, which is the Clerk of Parliament and others, must do an audit. The MPs have come. I'm sure they fill in forms to say, who are you, what are you, what is your thing. They must be able to identify MPs who need the capacity building, and not capacity building of the workshop type. You come for just 4 hours and you're gone and so forth. They must do it thoroughly. I mean, imagine if the session we are having with Justice Dingake today were a session that were available to almost all members of Parliament in Southern Africa and so on. I'm sure there have been some good things that have come out of this session, and it would benefit many MPs. And if that is the case, why are we not providing resources for capacity building so that we know that the first year of a 5-year term, capacity building, then the next 4 years, the country reaps the rewards of a trained member of Parliament who knows what to do, how to maneuver. Whereas people are calling for dams, the MP will still be able to call for dams or to call for, deep tanks, how they should be dealt with, fine. But the same MP who is able to do that is able to ensure accountability by the executive. He's able to nip out corruption. He's able to make the judicial accountable. This is best, things like that. We don't want an MP who simply sits there and is unable. I believe that it is the executive that is not wanting to provide resources for training. The executive does not want a powerful parliament. We must know that the executive wants MPs who are just sitting there waiting possibly for a ministerial appointment to be identified by the president. The executive would want a parliament which is simply a rubber stamp. Even they would want that kind of parliament. So they would not want you to get trained. And I think the best way of doing it is parliament must put up its own budget and pass that budget on condition that there are enough resources for capacity building. Take the first 6 to 12 months of a parliamentary session to deal with empowering MPs and allow the last 4 years to be really the fruits of our gain. We cannot afford not training and sensitizing MPs or capacity building MPs, even if they are going to be not coming back to parliament. We would have had a former MP who is also a very useful citizen. And so this must be a daily sort of thing that ought to happen. Madam Chair, because I know that we only have 1.5 hours this afternoon, I will now just summarize the 5 points. I have registered 5 points that I give Justice Tingake his time to it is time to be just intervene, and then we deal with your questions, some of which I'm actually seeing being posted by the secretary. But the point that I want to do now is to just summarize for you the 5 points that I made this afternoon, is trying to ensure that Parliament becomes more effective in protecting the rule of law, in protecting constitutionalism. I said, number 1, Parliament must know that it has a special relationship with the judiciary, and it must protect and support the judiciary so that the judiciary becomes independent. And an independent judiciary only arises if we get a very supportive parliament. That's what I mean. A judiciary will never get a supportive executive. Just as the executive wants to have a weak parliament, most executives also want to have a weak judiciary. So you two, Parliament and the judiciary, you have that special relationship, and I am saying there you must support the judiciary. I think I've indicated, you'll check your notes. Then the second thing, I said that that Parliament must work out clear ways of making public participation more sensible, more effective, and so forth. And that can be done by the methods that we have discussed. That was the second point. Then the third point was that Parliament must attend to its standing orders, to its rules of procedure, to ensure that those rules of procedure are more democratic, they are more sensitive to the rule of law, more sensitive to constitutionalism. They open space for the freedom of MPs. They open space, for ensuring that Parliament is not abused by ministers who may not want to answer questions and so forth. Then number 4, I said Parliament must know that it has a very special role when it is given the power to deal with the head of state or the head of government through votes of no confidence and impeachment. So Parliament must always be prepared for that. It can happen at any time, like the example I gave you of Zimbabwe, where the parliamentarians just from nowhere, they suddenly found that they had to do an impeachment when they had never prepared themselves for it. So Parliament must not have provisions like this thinking they will never arise or it will never happen. Parliament must always get preparing itself for that. That's a heavy responsibility. Then fifthly, I said that there is need to sensitize MPs to the issues and to do capacity building. And I've seen that one of the issues being posted there is, how do we deal with the problem that resources are not easily availed for that purpose? But I don't know why this question keeps arising when Parliament itself is the one that votes money. There can be no taxation without parliamentary vote. There can be no money spent anywhere without a parliamentary approval. So why should Parliament not insist itself that we want in this budget to have so much money that must be given for parliamentarians to deal with the capacity building thing? It can also make, Parliament can make certain rules, or when it passes certain laws, it must ensure that in those laws, there is minimum standards that are put for capacity building of MPs. Those will be my 5 points summary, Madam Chair, and I leave it at that for now for this afternoon. And I'm sure that's time for Justice Tingake. Thank you, Madam Chair.
Acho que pode dar continuidade o juiz Dingag, para depois entrarmos ao debate.
Thank you, Madam Chair. May I first establish whether I'm with all of you? Am I heard over? Everyone can hear me?
Interpretation, are you good? Can you hear Justice Dingake?
They are not responding.
Yes, sir. Yes, sir.
Am I clear? Everyone is on board?
Sure.
We're all awake.
You are very clear.
Aqui estamos a ouvir perfeitamente.
So then I'll continue. Thank you very much, Professor, again for a very brilliant submission. I agree very much with pretty all what you said. I think we are agreed, as the professor keeps on emphasizing, that Parliament has a role to play in the protection of constitutionalism, in advancing the rule of law, in deepening democracy. I think we agreed. And there is a disconnect when, although Parliament has all those powers, it still falls short of delivering on its mandate most of the time. That is one area of concern that maybe it also speaks to the need to capacitate members of Parliament to formulate cost programs, because we cannot overemphasize this point, that only an independent, well-informed, knowledgeable, I'll add in certain circumstances, courageous Parliament can we make advances that we need to make to protect constitutionalism and the rule of law. The professor spoke about the relationship between Parliament and other players. It used to be wrongly thought that maybe the mission or the duty or the function to advance human rights, to protect constitutionalism and the rule of law, maybe it's a function of the judiciary alone. That was, if ever there was such a view, it was very erroneous, because members of Parliament are constitutional actors. They are human rights actors, and they should take themselves seriously as such, and never even once should they subordinate themselves to any of the organs of the state of which they are co-equals. Never. If they subordinate the institution of Parliament to any other entity, any other arm of the state, that would be a betrayal of their constitutional mandate. The relationship between Parliament and the judiciary is key. Those are two organs of the state charged with different functions in terms of the separation of powers. Members of Parliament must legislate for the good order and good governance of the country. The judiciary must uphold the rule of law, must interpret the laws and enforce those laws. But independence is critical when we speak about the judiciary. The findings, you may be aware that the findings of the 2016 Africa Integrity Indicators report, produced by the Global Integrity, an organization that promotes transparency and accountability, says that there is no judicial independence in about 50% of the African states. And there are still issues around the appointment of judges, that the appointment of judges are not merit-based. And it's also extremely important that Parliament must ensure that judiciary is manned by men and women of integrity, of knowledge, and of courage, and of integrity, in order to protect constitutionalism and the rule of law. And this is the duty of Parliament in those countries where Parliament has a role in the appointment of judges. We need a merit-based appointment process that is transparent and fair, in which the judiciary represents the entire demographics or sectors of the country. That is the primary duty of members of Parliament. Unfortunately, not all constitutions actually give Parliament a role in the appointment of judges. I know of a few countries in which Parliament has totally no role. In those countries, it may be time for them to ask the question whether, as representatives of the people, it is not time that they must have a role in the appointment of judges, including in the removal of judges. So the independence of the judiciary is critical, and I cannot emphasize more than the professor did that among the things that we expect Parliament to do in order to enhance the independence of the judiciary is to give resources to the judiciary to properly execute its constitutional mandate. And you, members of Parliament, have responsibilities over budgetary allocation. One of the key problems that undermines judicial independence is the financial autonomy of the courts. In many of our jurisdictions, the courts are considered as part of the Ministry of Justice or some ministry, and their budget items comes under some ministry. That cannot be in accord with the spirit of the Constitution, the spirit of constitutionalism. So we need to give the judiciary sufficient resources to carry out its functions. And the judiciary must have financial autonomy over its own affairs. And it should not at any time ever be forced to go begging before a head of state or a parliamentary committee to say that we need money for this and this. Because we know that once you are a beggar, you become vulnerable to influence. And we do not want our judges to be vulnerable to influence. Because the state, the president, the ministers, and everyone is a regular litigant before our courts. And the requirements of our constitutional spirit of our constitution and constitutionalism is that once they come before our courts, they are immediately demoted to a status of an ordinary litigator in the same status like any other litigator. So they should not be reduced to a status of beggars. So this Parliament can do to ensure that resources are given to the judiciary. They can pass legislation that guarantees financial autonomy to the judiciary, that chief justices don't go before the president to beg for money to do anything. If you do that, you will have executed your mandate of promoting, protecting constitutionalism and the rule of law. The executive has the purse. It also has the arms. The judiciary has nothing. The only thing they have is their moral authority. And that moral authority often dependent on the public confidence that they have, the only lifeline for the judiciary. And to remain credible, it has to be independent, including independent of asking for funds from the executive. So that is an important point that I emphasize. Then the professor also spoke about the need to defend the judiciary when it is under attack. I think it's a very important point. Not to say that the judges can't err. In doing so, you are not defending the individual judges, but you are defending an institution, which is an arm of the state. Judges are not sacred cows. We are not sacred cows. We make mistakes. We make mistakes. We can be criticized. We are not immune to criticism. We must, in fact, be criticized from an informed, respectful position. But it's important now and then, where it is unwarranted, to see members of the executive stand the ground to defend the institution of the judiciary, which is a public institution. It is very rare. Last time I had occasion to listen to President Ramaphosa when the judges were being attacked, not many, a month or so back, and coming to the defense of the judiciary, saying nothing can justify any unjustifiable attack on the judiciary. Public participation. Public participation is key, as the professor said. I can't emphasize that point. In fact, in terms of international and regional legal norms, the public have a right to participate in the conduct of the national affairs. And members of parliament can actually facilitate or ensure the participation of the people. But in consulting the people about how they should be governed, about whatever legislative program the government is thinking about, it is important that parliament must indeed take on board the views of the people. Because what parliament, the powers of parliament, including the powers of judiciary, are delegated powers, delegated by the people. So the judiciary exercises delegated power, judicial power, and so are members of parliament. Our principals are the people, we the people. As most constitutions start their constitutions, we the people, we the people. So that spirit of we the people must always ring loud to every member of parliament. There is no point in consulting the people if their views mean nothing. If their views mean nothing, there's no point in consulting them. So by way of just emphasizing what the professor said, I want to return to the other theme because it concerns me. I highlighted it earlier in the morning session, and in this afternoon session, the professor said I may make further comment on it. That relates to your duty to promote transparency, accountability, and anti-corruption. I alluded in the morning to the AU framework, the African Union Convention on Preventing and Combating Corruption. And our countries are devastated by corruption. So you pardon me if I keep on harping on this issue. While there may be some normative legal framework, the real problem appears to be that most of the anti-corruption bodies are not sufficiently independent and they are under the control of the executive. I think it is important for members of parliament to revisit the framework that establishes these anti-corruption bodies and determine whether they are really, truly independent to go after everyone, to go after judges, to go after ministers, to go after MPs, to go after presidents. Are they empowered to do so without fear of being fired, without fear of recriminations? I think we need to pay attention to that. We need an enabling framework that criminalizes corrupt activities, enhances transparency in public procurement, and requires public officials to regularly declare assets and liabilities, identify and prevent conflict of interest, which is conflict of interest in the procurement, even of recent with COVID having ravaged our people. We had stories in a few countries where some people, including leaders, have taken advantage of the pandemic, of the disaster, to engage in corrupt activities. And we still have a situation in most of our countries where there is no sufficient protection of whistleblowers. We need to attend to this gap. And we need to ensure that the legal framework is strong and robust to enable tracing, seizure, freezing, forfeiture of all illicit earnings from corruption. Once we do this, then we will be fulfilling our functions and protectors of constitutionalism and the rule of law. I do not know, because of time, whether I will have another chance. If I will, to conclude, I think I'll stop there because of time, but hoping that I'll have some concluding opportunity. Thank you, Madam Chair. Thank you, Madam Chair. Is there anybody there?
Sim, sim. Muito obrigada. Muito obrigada. Muito obrigada aos nossos palestrantes. Convido agora os colegas para alguns esclarecimentos, algum questionamento. A sessão está aberta. E passo a palavra agora, tenho indicação de o senhor vice-presidente, vai intervir. Por favor.
Chair, thank you very much. And thank you very much for both presentations. I think it was a very interesting conversation, and I think very good in theory. I think the practice in the 15 countries that represented here, we'd probably find that there's differences in our experiences. I think what we need to understand, though, is every time we make a law, if it's not realistic, if it's not enforceable, we are making criminals out of people. And why I say that is that what we found is that let's say we make legislation that littering is a criminal offense. If people start getting away with that, they find that they can throw away rubbish outside the window, and no one catches them. Then when we say that chewing gum in the streets is now illegal, when they start chewing gum in the streets, they know that they can get away with that. So what happens is it becomes easier and easier to get away with legislation. So the challenge is to make legislation that we can enforce and legislation that is realistic. And I think this is where, between the 15 countries, I think we sometimes get it right or wrong, is that we look at each other or to each other, and I think we make legislation that sometimes it's just a step too far, and we make legislation that, I don't want to say it makes criminals out of people, but it almost makes it unbelievable in terms of the legislation. The second thing is the Constitution, is that where we have a Constitution, who's the guardian of the Constitution? Now, you've suggested, Justice Dingake, that it's almost the parliamentarians should be the guardians of the Constitution, but in South Africa, it's often been that we've run to the courts, and the courts have had to protect the Constitution, because they've had to say, well, our interpretation in the Constitutional Court is such that we actually suggest that the Constitution says so and so. And if you look at the Constitution in South Africa, it was in 1994 when it was introduced. It was probably, when it was being created, the people that were gathered around the tables in 94 were preparing a constitution that they believed was protecting citizens that were, that the path of leadership was moving towards a certain direction, and maybe weren't preparing a constitution that maybe the path of direction has now changed. So now you've got people now in legislation that wants to change a constitution, and an entrenched constitution. We've seen in Zimbabwe there's what we refer to as restorative justice, and it has been said that President Mugabe had what has been said as successful restorative justice and recognized as successful restorative justice. But you look at a constitution and you say, who has the right to amend the constitution? Is it the parliamentarians, or do you approach the courts? Where does the power lie when it comes to the protection of the constitution, or having the constitution? And I find it an interesting, I find it interesting that when it's the people that the constitution is created for, they really don't have much of a say, because it's either the 400 people in an assembly, or the executive, or they have to approach a court for their voices to really be heard. And so I think that what we're discussing here is obviously very important. But when it comes to the 15 countries, we each have it differently. We each have a different experience on who is the custodian of this constitution, and how we roll out the challenge of how we can challenge being heard in this constitution. Thank you.
Muito obrigado. Passo agora, tem a indicação do deputado Doene, por favor.
Thank you very much, Madam Chair, and thank you very much to Professor Maduku and Justice Dingake for their presentations. I wanted to look at SADC, PF, or SADC as a whole. You see, whilst we strive towards constitution, I always bite my tongue when I say this word, constitutionalism and the rule of law. When we look at it, why don't we come up as SADC with model laws as for a start? Because we have already model laws on elections, we have model laws on child marriages, and model laws on HIV. Why don't we start off as a starting point, have the model laws, so that we get a buy-in from member countries? I personally feel if we start off that way, we might have a buy-in in some countries domesticating these model laws, and we move towards a good governance and a good governance and a rule of law. That's my number one point. My second point is I wanted to ask Prof. Maduku. Some jurisdictions appoint their ministers outside Parliament. So my question is, what is your take on appointing ministers outside Parliament in promoting good governance and constitutionalism in a country, sort of that type of approach where ministers are not picked from members of Parliament, but they are picked from outside Parliament? Can it improve even corruption as well? I thank you.
Obrigado, deputado Doene. Tenho a indicação da secretária-geral Faz favor, senhora secretária-geral.
Thank you, Chair. Thank you very much, Honorable Agostino. These are very interesting discussions that we're having this afternoon. I'll start with the simple question based on the presentation by Prof. and Justice Dingake. Simply to ask, how do you protect parliaments from interference of the judiciary? And I'm saying this building on the assertion that the professor made earlier in relation to the development of the rules of procedure and standing orders, that these are done in isolation and without any interference of any arm of government. But I believe that there are case studies elsewhere that go as far as even giving judgment on committee work of parliament, which was based on the guidance of the rules, among others. The last question that I have, if you can indulge me, Madam Chair, is that the first and most striking challenge I'm presented with is how to ensure the reputation and integrity of the institution of parliament itself is contained and sustained at the level of the SADC Parliamentary Forum. And there's been a heightened level of scrutiny that parliamentarians are faced with of recent years, mainly from donors and also from the executive, in terms of whether a parliament is weak or is strong, or whether indeed parliament's capacity development, value addition for capacity development yields any positive outcome. And I like the fact that the professor emphasized and the justice emphasized the issue of capacity development, which is a key pillar for us at the SADC Parliamentary Forum. But I would like to know, how do we ensure that the outcome of any capacity development yields value for money at the end of the day? And I'm saying this underlining the issue of political party whipping, the conscience and ethical conduct of the individual MPs, among others. Because at the end of the day, when we stand up and speak for the institution of parliament, we often lubricate democracy and the role of parliament as a value addition. And I would like to hear from practical experience what actually happens in these cases. What is the value proposition that we can put forward to still have the integrity of parliament intact? I thank you, Chair.
Okay. Caros colegas, não tenho outro pedido de palavra. Posto isso, convido os nossos palestrantes para algumas considerações, algumas respostas. Por favor.
Through you, Chair. I'm struggling to raise my hand because I've been made co-host.
Okay.
So I have the dilemma. Could I also pose a question that I had posted in the chat?
Pode intervir, Sr. Secretário, pode. Desculpe, é que não vi a indicação.
Thank you very much, Chairperson. On the issue of public participation, I've come across a statement that reads, democracy means that the minority will have their say and the majority will have their way. And in scenarios where there is political domination, part of it backed by electoral outcomes, there is almost sometimes an exclusive understanding that this mandate stretches for 5 years unquestioned until the next election. And my question is then, how do we balance the need for meaningful public participation in public affairs, even in the event where, or situations where we have political majorities or 2/3 majorities in parliament? I thank you very much, Chair.
Não tenho outra inscrição. Convido agora aos nossos palestrantes. Por favor.
Okay, thank you, Madam Chair. I'll take in, I try and give the answers to those questions. I'm sure Justice Dingake will come in and add some points. I saw the first observations from the Deputy Chair were clearly observations. I find a lot of merit in what he was saying. The Deputy Chair of the committee from South Africa, I certainly found them quite useful comments. So I have no responses to give except to make that observation that it's useful observation. Then the second question that came from Zimbabwe, the Honorable Ndiweni there, he has two areas. The first one is on a model law. Why can't we? I mean, that would be a brilliant idea. In fact, the whole concept of having SADC or have AU, it would be good where we can attempt model laws, we would be better off. But they require a lot of political will to be able to come up with a model law. And they will be shot down by most of our leaders. So I think that many of our leaders would not want a model constitution that we can all try and buy into, and so on. So this is what would be the problem. But it is a good idea. It's actually a useful way of looking at things to say, can't we have a model thing? If you were, I'm sure you were following what Justice Dingake was saying in relation to what Parliament can do. He was saying, for example, yes, I know of countries where this role is not provided for. I know of countries where this role is not provided for. I mean, we should have a model framework of what Parliament does. Let's say with the example we took this afternoon of the relationship between Parliament and the Judiciary. Should Parliament be involved in the appointment of judges? Let's put that question, for example. Why are we not having some model approach in the whole of Southern Africa and the 15 countries? We can answer that issue as 15 countries and say that we believe Parliament must play this role when judges are being appointed. And then, for example, we go to the next issue we also addressed this afternoon was how much resources should be given to the judiciary and how do you measure these resources? What role is Parliament playing? How has Parliament been playing that role in other countries? How we can have models around that. So you are very correct that we can have a model, and I would support that, and I think everyone will support it. But it is to get the model, which will be very problematic because countries have different ways of approaching the matter. But I would agree with you there. Then that takes us to the question you posed about whether ministers are appointed in and outside the Parliament. The typical American approach, which is still only in the United States very extensively so, and I think there are a number of countries that have followed that. You will see what the Kenyans have done along the same line. You elect the president directly, and then he or she must pick ministers from outside Parliament so that there's complete separation between the executive and the legislature. So you don't have MPs who are sitting there every day hoping to be recognized for appointment as a minister. You get people who know that if I'm in Parliament, I'm not going to be part of the executive, so I'm going to make the executive accountable. So that is the advantage of a system where members of Parliament, so the ministers are not appointed for members of Parliament. It is supported on the basis that you are likely to make Parliament more effective in ensuring accountability. There are no people looking out for careers and so forth, and then not doing as much. And also even party political affiliation might not be as serious as what you find where you take ministers from Parliament, because you are taking ministers from the same MPs who would have been part and parcel of the same camp that was campaigning in the areas, whatever. So that has been the advantage. I would not say it is necessarily the solution, but I can tell you that those are the reasons that have been given for those who support it. And then they say the only person who is accountable is the one who elected directly. The president must be able to hire and fire those people. And he is one who should answer, but he must get a competent team. that he gets from anywhere. And this is where that issue is coming. But on the opposite, the reason why people say the systems that require ministers to come from parliament, they are based on the British system, where in fact the government is a parliamentary executive. It's a parliamentary system. Those who go into government are actually the executive. All ministers, the prime minister comes from parliament, ministers must come from parliament. The philosophy there is that it is parliament that is governing. And then it is a few people that are picked out of parliament to actually do the day-to-day running of state. You would see that that system's philosophy is that government is nothing but an executive of parliament. That's how the Westminster, the British approach takes in. And so in that case, they would want the people's representatives to be in government, because the separation between the executive and the legislature in the British system is very weak. They simply, yeah, they are really one and something. Imagine that the prime minister is the head of government, but the prime minister is also an MP. He will have his constituent somewhere, and he comes in to be the prime minister. And this is what you have seen in most of European countries do have the prime minister coming from parliament. They don't elect the president directly. So I think I've answered you that, well, it's yes, no, it depends on one's political perspective. So there's no real right position, but you can choose for yourself what that. But in Southern Africa, we have generally tilted to the fact that we get our ministers from parliament. And then we give the presidents just 1 or 2 or 3. In Zimbabwe, it's 5. In South Africa, it's 2 ministers you can get from outside parliament, and so on, things like that. You do get this position clearly. Then this is from, I think, from Honorable Nduen from Zimbabwe. I'm sure I've addressed those questions. Then there was also a question from the Secretary General on how do we protect the parliament from the judiciary and so forth. Well, it is very difficult to take the judiciary out of these issues. But I think a principle must be established that generally when parliament is operating within its own rules, the courts will not interfere. That is the general trend around the world. And that where they come in and interfere, there ought to be a good reason, like if they say there's an infringement of rights or an infringement of constitutional provisions, they would be. So it's a very difficult balance to maintain between a really independent parliament with its own orders and so forth. And that must be, one must strive towards that. But if we talked about capacity building and so on, I mean, there's nothing wrong with also exposing the judiciary in appropriate fora, in appropriate workshops to these things. They can get one among themselves, like you can have Justice Dingake there addressing a workshop of judges across, or you get professors also coming in to do that. Even the judiciary also wants to really be exposed to these things, to know that there is value in an independent parliament. And then you come in. So the general principle has been, you cannot, because of the constitutional supremacy, take away the judiciary if there is a dispute. But the judiciary must not go too far in it. If there are countries where this is happening, the way out of it is to raise it, get some criticisms going around. It will reach the judges through publications and so forth, and you get that. Now, one way which we have seen around is where, a secretariat like yours, the SADC PF and others who are worried about these things, they develop literature, ask academics or judges to write around the subject. We can have a clearly written topic or pamphlet or monograph on the role and relationship of parliament and so forth. Then we write that what should be the ideal relationship. And then we get literature around and we tell them how it has happened in many countries around the world. The well-known position is that unless parliament has gone outside the frameworks that are parliament, the courts must stay out. In the British system, because of the absence of a written constitution, they actually had an excess process where parliament was judge of its own internal affairs. But that has, of course, been watered down. But the principle remains. Don't get in. The Americans who are at the forefront of trying to create a constitutional, they also have very good constitutional law. where the courts will not interfere with the activities of Congress or internal dynamics of Congress. See, it'll be very difficult to get a matter in Congress going to the court. I'm sure you saw that President Trump, when he was facing the impeachment, even decisions relating to whether they could do it were made within that. So that, I think, would need to be considered in that regard. Then the Secretary General also asked a question relating to how you can guarantee the outcome, value for money, when you train MPs, and then the MPs will then go out, then simply behave as though they were never trained. They will just take the instructions from their parties and so forth. And they more like you feel completely bad that you have wasted money, but the MPs are not. I think the answer to that is that you have to be very patient. The outcome of capacity building frameworks won't be seen on year one or day one. I think that it will take some time. More and more investment in capacity building, you will see changes coming in. So don't look for immediate results, because as you invest in capacity building of create patience there. And apart from that patience, I don't think that you lose out. There are MPs who, because in the capacity building process, you must also deal with the question of what is the role of the party whip? What is the role of the party? Properly trained MPs will stand against interference, and we'll soon see many of them. I don't think the parties will be firing left, right, and center everyone who is not. But I want to appeal to you in this case to ensure that we are patient, we take time. I think let's invest in it, and we'll get fruits 2, 3, 4 years down the line. The fruits will be clear. And that the most important aspect, like I said at the beginning, Parliament is a separate institution from the members of Parliament. So you can't just say because I am a member of Parliament, then whatever I do is Parliament. No, Parliament must be kept as a separate institution, but this requires the thing. Then the final observation related to the whole concept of whether democracy is all about this concept that the minority will have their say while the majority will have their way. That is no longer the correct conception of democracy. Under a proper democracy, the minority will also have their way. It's not just their say, they also have their way. This is why there's so much protection of the judiciary and so forth. And that if the majority will behave in a way that is undemocratic or that is contrary to the Constitution, then this is where you bring in the other arm of state. That's where you bring in the courts to assist the minority have their way. That's the way. And so we must teach our people that this is a very old notion of democracy, that the majority will have their way. You can have your say. In other words, you can talk and talk and then we listen, but at the end, we don't have to do it. We'll do whatever. In other words, after all has been said and done, we'll still do what we would have wanted to do. That's, I think, what Justice Dingake cautioned against, that, look, democracy is about involving the people. When we say involving the people, we mean involving both the majority, whoever claims to be in the majority, and the minority. But in many cases, public participation gives room to the minority that is active, because the majority also tends to be lazy. They just vote and disappear. So in a democracy, we must be very careful that we put that. So I hope I have just put insights on that issue that has been raised by Shiones from Secretariat, whether I would discourage people who spread messages around the issue of democracy is the majority having its way and the minority having say. A democracy is where both the majority and the minority have both their says and sometimes their ways. The majority may not have its way every time. They may have their way in sometimes, or in the majority of cases. But we must build societies where the minority will be able to do that. Those would be my really requests, answers to the questions. And I also hope to say that I can give my final remarks, which are to be quite confident that this has been a very useful. I benefited a lot from my intervener and then also from the questions that have been coming. It appears that this is the kind of session that ought to be spread out to more members of parliament across the region. Thank you, Madam Chair.
Muito obrigado. Agora passo a palavra para o juiz de Ngag. Não sei se tem alguma coisa a nos dizer.
Is it my turn, Madam Chair? Should I proceed? Should I proceed, Madam Chair? Thank you very much. I think my friend has answered most of the question. I just wanted to say, because there is no time left, that most of our countries have a Bill of Rights or have constitutions that say they are the supreme law of the land. To that extent, I think it's correct to say that the courts are the guardians of the Constitution, where the supreme law of the land is the Constitution, and the courts are mandated to pronounce over issues of legality and the rule of law. But parliaments are natural guardians of the rule of law to the extent that they have legislative powers, their roles as national debating chambers, their oversight functions, and budgetary responsibilities. And indeed, as Deputy Chair from South Africa suggested, the 15 countries that make up SADC, or whatever number, although we share a lot in common, in fact, in terms of both saying that we want constitutionalism, the rule of law, equality, and all those, we seem from the same book, but our constitutions are different, and our statutory law to give effect to our values are different. And the institutions that were put in place to give effect to the promise of the Constitution also are different in some respects. So they are different results, although we share so much in terms of common values. But we all subscribe mainly to the doctrine of constitutional supremacy. I'm a big, coming to the second one, I'm a big supporter of model laws. My only abiding critique that I hope in the course of time the MPs could attend to and should help protect constitutionalism is to close the implementation gap. Honorable MPs and Honorable Secretary General, the next phase in around modern laws is to close the implementation gap. We must put in place some monitoring mechanism. We must put in place some monitoring mechanism in order to improve implementation. As regards the other questions posed by the Honorable Secretary General, in a constitutional supremacy situation, it is the province of the courts to determine the constitutional parameters of what each organ of the state can do or cannot do. When the question arises whether the courts must intervene in the work of the parliamentary committee, it is the courts that have the power to determine whether it can do so or not. And usually, if the parliamentary committee has followed its rules, the courts will not intervene. But where there is an allegation of breach of the law, breach of the Constitution, the courts will intervene because it is their duty to do so as the guardians of the Constitution in a constitutional supremacy. So that answers that part of the question. And of course, we have not had time. There is a lot, because of the growth of judicial power, there is a lot that the judiciary is also doing that may be taken to be violation of separation of powers. To give you an example, recently in Papua New Guinea, for the first time, I think Maduku I don't know whether Maduku you have come across this. I taught constitutional law at the University of Botswana. I'd never come across it until 2 weeks ago when I heard that the PNG Judiciary, the Supreme Court of Judiciary in PNG nullified the passage of the budget in PNG, which was passed by Parliament. The court struck it down as null and void and of no force and effect, and directed the Parliament to go back and debate that budget.
I can
So
intervene, Judge. Let me come in. I think I would want to. I haven't come across that. I'm very interested in following that up and hearing, getting from you.
I'll send you some write-up on subsequent report on that one.
All right.
So I think I've answered the question that I wanted to answer, but I agree that we must not tire to capacitate Parliament. The results may come slowly and it may take time, but we should never tire. But as I must emphasize again, we as individual MPs must introspect and say what is our role, and have courage and be able to follow through our mandate without fear of favor. We must have a transformed mindset if we were to deliver on constitutionalism and the rule of law. And by way of conclusion, I think we can't emphasize more to conclude the independence of Parliament. And Parliament must find mechanism to work closely with civil society and non-governmental organizations over time. And they must be able to introduce bills, even private members' bill, to advance constitutionalism and the rule of law. There are so many things that Parliament can do. Maybe what we need going forward, just thinking loud, maybe the time has arisen for SADC PF to explore the potential for some regionally agreed principles and guidelines on the role of parliaments with respect to drawing on good practice across other regions of the world. I think SG, you may wish to take note on this, and we can discuss if you need that. I think it is time that you must consider some regionally agreed principles and guidelines on the role of parliaments. And at some stage, you must convene a high-level regional conference on this particular topic, now involving a larger audience, including members of the executive, civil society, academia, and members of and other groups. And lastly, maybe you also need a research project to find out the extent to which members of parliament are in actual fact fulfilling the roles. That study may be quite interesting. Whether indeed all these roles that they're supposed to play, whether in actual fact, I think Professor Maduku would love to run with that one, whether in actual fact in the region, whether it is happening. And let's see the evidence. And thereafter, our actions, let them be evidence-driven. Thank you, Madam Chair, for the opportunity. I appreciate it.
Muito obrigado. Caros colegas,
Chair, your microphone is muted. Apologies.
obrigado pela atenção. Dizia eu que estamos a passos largos para o fim dos nossos trabalhos do dia de hoje, mas antes de encerrar, convido agora o secretário para alguns anúncios. Muito obrigado.
Chair, I missed your intervention. Apologies. I had to attend to some administrative matters. Okay. Chairperson, thank you very much. In terms of the announcements, it's to indicate to the committee that out of this of the procedural work that we must do. Those are the three things that we are going to be producing from this meeting. We had a rapporteur who was taking the record, and we'll be working with the rapporteur as the secretariat to produce the policy brief, the report, and the minutes. Thank you, Chair.
Muito obrigado, senhor secretário. Caros colegas, chegamos ao fim dos nossos trabalhos. Gostaria de agradecer a participação dos distintos colegas nesta reunião. Quero também, em especial, agradecer ao nosso palestrante, o professor Maduco, e o nosso interveniente, o juiz Dingake, pelas brilhantes apresentações. O tema apresentado é muito atual e permitiu que os membros da comissão tivessem uma visão coletiva sobre o constitucionalismo e o Estado de Direito no concernente ao papel do Parlamento. Caros colegas, continuemos a nos cuidar da Covid-19, para que dentro em breve possamos ter as nossas reuniões presenciais. Depois dessas palavras, declaro encerrado a nossa reunião. Muito obrigado, caros colegas, pela vossa participação e pelo vosso desempenho. Obrigada. Declaro encerrado, né?
Thank you, Madam Chair.
Thank you, Chair. Host, kindly terminate.